The second Schrems case, which people often are talking about in a moment, was argued before the Court of Justice in July 2017. Now, I represented Max Schrems before the Court of Justice in the procedures which had started in Austrian courts. So this case is called Schrems against Facebook and had been referred to the Court of Justice by the Austrian Supreme Court. It had started as a litigation by Max Schrems, who brought a damages claim against Facebook for violation of his data rights and privacy rights, for Facebook having transferred his data to the NSA, and for Facebook having misused the data which he had uploaded in use of his Facebook account since 1998. He was one of the early users of Facebook for advertising and other non-authorized purposes. Now, Max Schrems brought the case at his residence in Vienna as a consumer. However, before he brought the case, he had publicly stated that he would do so and received so much interest by others saying they would like to join him or support him that he had written overnight, together with a friend, a computer scientist, an application by which other consumers were able to transfer their claims to him. So within a very short time, 25,000 people had transferred their claim to Max Schrems. After it became impossible to handle all these cases, Max changed the situation and said, now you can only declare your interest. And after 50,000 additional individuals who declared their interest to transfer their claim to him, he shut off the app and said, that's enough now. And together with his own claim, brought 6 other claims as a test case, joining them together. These 6 other claims are claims from individuals who live in other areas of Austria, so with other districts of court responsibility, other member states of the European Union, and a claim from a third country, from India. Now, under Austrian law, if you transfer a claim, the person which receives that transfer becomes the owner of the claim, and therefore brings his, originally his, as well as all other claims which have been transferred to him, in his own name, as if he were the original contract partner. Now, the Austrian courts were doubtful about the admissibility of such claim, and doubted especially whether Max Schrems could be considered as a consumer, having the right to bring a claim for damages against Facebook under European consumer protection rules at the place of his residence, or whether he shouldn't have brought this joint claim at the seat of the company Facebook Ireland in Dublin. Under Irish law and Irish court rules. So essentially the issue in Schrems number 2 is, can an individual consumer join other consumer claims in order to request a payment of damages from a company? And essentially what is behind this question is there the possibility for consumers to organize themselves in order to enforce their rights under European law? Or is the system set up in a way that predominantly consumer organizations are allowed to act, but as an organization, they then can't claim individual consumer rights and residence of consumer rights? This issue is, of course, somehow linked to the complexity of a multi-level legal system in Europe. And one of the problems would be that if one accepts that one is not a consumer and would have to go to litigate such issue in Dublin, at the seat of the company, one would also have to admit that, not being a consumer, the choice of law clause of the Facebook contracts which choose Californian law and Californian jurisdiction of courts should be possibly valid, with again the problem that such judgment, if it were ever to be achieved in California, could not be enforced in Europe, which means consumers would be devoid of effective judicial protection. And as we know from Schrems 1, the right to an effective judicial protection is an essential right of individual. It's a meta right because it applies to all kinds of matters, and the denial of justice is a very serious issue. So essentially, the question in Schrems 2 is, can individuals get together and enforce their rights in Europe and have a standing vis-à-vis big, powerful individual companies in order to enforce their rights granted to them under European law? Schrems 3 might come. It's actually beginning of October. The High Court of Ireland will decide about a case which in this case was not started by Max Schrems, but still will end up potentially before the Court of Justice. The fascinating thing in Schrems 1 was that the Court of Justice obliged the national data protection authorities to keep an eye on not only the compliance of companies under their supervision with European data protection law, but also to make sure that where national data protection authorities have a doubt about the legality, for example, of the successor of the Safe Harbor decision, the Privacy Shield decision, or other types of Commission decisions in the context of enforcement of privacy and data protection rights, such as the Commission decisions on common contract clauses, that where those doubts exist, national data protection authorities must have an access to a national court in order for a national court to be able to ask a preliminary reference question to the Court of Justice under Article 267 TFEU. So, what the Court of Justice in Schrems 1 had requested member states' legal systems to introduce was a kind of a declaratory procedure by which public authorities, in this case data protection authorities, could ask clarification of the legality of European law. The Data Protection Commission of Ireland did what it was requested in Schrems 1. It had doubts, expressed doubts about the legality of certain Commission decisions in the context of transfer to the United States, and brought a case to the High Court, asking the High Court to review its doubts and, if it shares these, to transfer the case to the Court of Justice. The only problem in that context is that under Irish law, a defendant must be named. So the Data Protection Commission of Ireland named Max Schrems as complainant and Facebook as other company who was element of the complaints of Max Schrems as co-defendants, which makes for a very bizarre context of litigation, because Max Schrems hopes that the Data Protection Commission of Ireland would win. Facebook doesn't hope so, yet they are co-defendants. And Max Schrems has to expend enormous amounts of time, take huge financial risks in the context of litigating in a situation where he was an individual student from Vienna who had done what his rights under European law are, to file a complaint to a data protection authority in Europe with a request to review whether his rights had been violated or not. The proceedings before the High Court have been lengthy and interesting, since the High Court had not only heard all kinds of actors, but also had admitted as intervenants the United States government, certain NGOs, certain companies, and therefore had a collection of evidence and review of the issues well beyond anything which had been done before. So if the High Court refers to the Court of Justice, that would become Schrems 3, and it remains at the moment of this interview to be seen what kind of questions the High Court asks, whether the High Court will ask about the legality of the successor decision to the Safe Harbor decision, the Privacy Shield decision, and whether the High Court will ask about the legality of Commission decisions in the context of standard contract clauses.